I'm audible? Okay. So let me know if I'm audible, if I'm visible. So am I audible? Am I visible? Just let me know. Once it's done, I'll just stop it, right? आप कर ही दो recording में जाओ करना है ना. Hello Chaitra, how are you all doing? I hope your studies are going good. Thank you. Bye bye. Hello, hello, hello. I hope your studies are going good. Yes. So today we are going to discuss the mock test paper. We're starting with the mock test 2. Okay. Just because, I mean, considering the situations that are going on right now, and having heard that the CA inter exams have been postponed. Good, Chetra. And considering the fact that we all are under the impression that now CA exams have been postponed, so mostly even my CA foundation exam might get postponed. So let me not study right now. Please don't go into that right now. You just keep studying as you have been studying, right? So please don't stop studying. Keep studying as you have been studying. So today we are going to discuss the mock test paper. So ICI has, ICI conducts 2 mock test papers every term, right? So we are going to start with the second mock test paper. And once we are done with the second, next week sometime we'll do the mock test 1 also. So tell me, have you actually seen the question paper? Did you see the question paper? Did you actually analyze the questions? Did you go through the paper? Have you done that? Just tell me a yes if you have, okay? If you have done that, please just let me know with a yes. If you have gone through the paper, you have read the paper, tried to solve the questions. If you have, please just give me a yes in case you have. You have? Okay. Were you able to solve? Were you able to solve? Not able to solve? No, you did not. Okay. So what we will do is, no, I'm going to give the questions. I'm going to read the questions and I'm expecting you guys to tell me the provisions applicable for the question. Okay? I want you guys to tell me the provision that is applicable to that question. What do you say? We'll do this? What do you guys say? Just tell me a yes. If you think we should do this, just tell me a yes. So what we are going to do is, we are going to discuss I'm going to read out the question, expecting that you will tell me the answers, the provisions. We will also discuss, in this case, we are not just going to discuss the answers, we are also going to discuss the provision that should be given, that should be written in this answer for you. That is, when you are writing this answer, what all provision should be there in this answer, that is what we are also going to discuss. Okay? So as I told you, I am expecting you guys to answer the questions. So should I start, guys? I just want to see a yes from all of you before I start. Should we start? Should we start? Yes? Okay. So P, Q and R jointly promised to pay S a sum of 60,000. Okay. So can we say, yes, this is about joint promisers that they are talking? But I cannot be very sure that it is joint promisers only. I have to read the rest of the question. A sum of 60,000 examine considering the, okay, so they have said Indian Contract Act. So obviously we are talking about the joint promisers, right? So can S compel any of the 3 parties P, Q and R to pay him 60,000? Can S compel any of the 3 parties P, Q, R? So here, what I am supposed to write, I'm going to write about the liability of the joint promiser. And when I say I'm going to write about the liability of the joint promiser, I have to write that their liability is joint and severe. And I also have to write that one of them can be compelled to pay the whole amount. That is, the promisee can compel any one of them to pay the whole amount. These things have to be there in my answer, right? Then R is compelled to pay the whole amount. So can S compel any of the three parties? Yes, because any one of them can be compelled to pay. R is compelled to pay the whole amount to S. Can he recover anything from P and Q when P and Q are both solvent? So they are saying, can he recover the money from P and Q? So here we also have to write about what happens if one of them pays, right? We have to also write about what happens if one of them pays. So if one of them pays, what will happen? That provision should come here. So can he recover it from both P and Q if they are solvent? Yes. If P is not in a position to pay anything, so here this comes about what happens if one of them is unable to pay. So we are literally covering this point also here. So when I write the provision, my provision should talk about the liability of joint promisors. We can compel any one of them to pay. Then we should talk about if one of them pays, what happens, and last we should say about what happens if one of them is not able to pay. We have to write all of these provisions. So P is not in a position to pay anything. So if P is not in a position to pay anything, then in that case, each of them, because nothing was given, each of them was liable to pay how much? 60,000 divided by 3, which is 20,000. If P is not in a position to pay anything, obviously I cannot recover anything from P, but I will recover the money from Q. But how much here? 30,000, because now if P is not paying, each of them is liable to pay 30,000. Correct? So if you look at the answer here, see, they have written that they have talked about, in this case, they have talked about they are jointly liable to fulfill their promise. Correct? Then they have told that the liability is joint and severe and we can compel any one of them to pay. Then again, they also say we have a right, they are liable to contribute equally, right? And if any one of the joint promisor makes default in such contribution, the remaining joint promisors must bear the loss. So all of this we have to write. Clear? Where you, I hope you were able to answer the question correctly. This answer you were able to write, answer the question correctly. Yes. Moving on to the second one. Oakwood Private Limited is a holding company of Silver Oak Private Limited. Oakwood is a holding company, sorry, of Silver Oak Private Limited. As per the profit and loss for the year ending 31st March of Silver Oak, we are talking about Silver Oak. The turnover was 1.80 crores and the paid up capital is 80 lakhs. The board of directors wants to avail the status of a small company. Okay. They want to avail the status of a small company. For a small company, your paid up capital should not exceed. I should be seeing answers here. You should be writing the answers also, right? For paid up capital, for small company, paid up capital should not exceed 4 crores. And turnover should not exceed how much? 40 crores, right? This is the limit. So the company secretary of the company advised the directors that Silver Oak cannot be categorized as a small company. But if you remember, this clause shall not apply in case of holding subsidiaries, special companies and Section 8 company. Now, if you look here, Silver Oak Private Limited is the subsidiary of Oakwood Private Limited, right? It's a subsidiary of Oakwood Private Limited. So since you are a subsidiary, holding subsidiary, you don't get the status of a small company. Now, the company secretary of the company advised the directors that Silver Oak Private Limited cannot be categorized as small company. In the light, you are required to examine whether the contention of the company secretary is correct. Yes, because it's a holding subsidiary, you cannot get the status of a small company. So in your answer, you have to write the entire definition of small company. So see, as per the small company means paid up share capital does not exceed 4 crores, turnover does not exceed 40 crores. Ma'am, if I don't write or such higher amount as may be prescribed, it's okay. It's okay. Provided that nothing shall apply to a holding and a subsidiary, it's based on this that my answer comes. So if you forget to write this part, your answer will not be proper. Because definition of small company is important. But because it's a holding subsidiary company, right? This clause actually gives the answer. So we have to write this one. You cannot forget to write this. So moving on to the next question. In Blossom Private Limited, there are only 5 members. All of them go in a boat on a pleasure trip into an open sea. The boat capsizes and all of them died being drowned. Explain with reference to the provisions of the Companies Act. Is Blossom Private Limited? You're supposed to write the answers, guys. I'm not seeing any answers from you all. Please keep writing the answers. And please, provisions are very important. Here I'm showing you what provision should come in your answer so that you don't miss out on what is supposed to be written. Okay? Is Blossom Private Limited no longer in existence? So here, this talks about what? Perpetual succession. So here you actually have to write about what? The characteristics perpetual succession. Further, is it correct to say that a company being an artificial person cannot own property and cannot sue or be sued? So here you have to write about 2 characteristics: right to own property and capacity to sue and be sued. So you have to write about these 2 characteristics. So if I look into the answer here, obviously the first part is based on perpetual succession, right? Then the second part, oh, finally, good. You should write answers here. You should write the answers. What's the point of attending the session if you're not writing? After some time, it will seem like ma'am's voice is nothing but a lullaby and you will go off to sleep. Keep writing the answers there, whatever you think is the right answer. Right, the statement. So first of all, what is the state? It is correct to say that a company being cannot own property and cannot be sued or sue. This is obviously not correct, right? This is obviously, this statement is not correct. So you will write the statement given is incorrect and you will explain these 2 characteristics to explain why the statement is incorrect. So you have to write about, it's a legal person created in the eyes of law and it has a capacity to hold property in its own name, have a bank account, and also since it's making a contract, the company has a right to sue in its own name, or third parties can sue the company in the name of the company, right? Explain the rules laid down under the Indian Partnership Act for the mode of settlement of partnership accounts after the dissolution of the firm. What is the order in which the assets of the firm are applied? What is the order in which the assets are applied? First for outside liability, then partners advance, then partners capital, and then if any surplus is left, that will be distributed amongst the partners, right? The assets of the partnership firm will be first utilized to pay off the partnership debts, and then if any surplus is left, that surplus will be utilized to pay off, will be taken by the partners in their profit sharing ratio. Correct? Again, also, whenever I'm using the property of the firm, including the partner's capital, first we will pay off the liabilities and then only the surplus will be distributed. So, see here, mode of settlement of accounts. Losses, okay. And obviously, yes, one thing I forgot, if there is any loss matlab if there is any deficit, right? Loss means if there is any deficit, that will be contributed by the partners, right? It will be contributed by the partners individually as per their profit sharing ratio. The assets of the firm will be first utilized in paying off the third parties, then in paying off each partner whatever is due to him for his capital, then it will be paid to him. This is actually advance, not capital. Then what is due to him on account of his capital, third, and then this is residue. Residue means what we are talking, surplus. This is wrong, it will not be capital here, it will be advance. Capital and surplus will be distributed by the partners in their profit sharing ratio, right? Then discuss the provisions relating to payment of firm debts and separate debts of the partners. How are the firm's property and partners' property separately applied? The firm's property will be first utilized to pay off the partnership debts, right? The property of the firm. So you'll write about both separately. Please understand. Answer what the question is asking you. Don't answer what you feel like. Here, what are they asking you? They are asking you how will the property of the firm be utilized and how will the partner's personal property be utilized for the payment of debts. Don't mix it, right? Don't mix it. So please listen very carefully. First of all, when we talk about the firm's property will be first utilized to pay off the firm's debts. After that, if anything is left, that will be distributed by the partners in their profit sharing ratio, that is the surplus. When we talk about, this is the firm's property. When we talk about partner's personal property, in case of deficit, partner will personally contribute to the deficit in the profit sharing ratio. We already saw that. If a partner has both both personal debts and partnership debts, his personal profits will be first utilized for his personal debts and then his partnership debts. So see here, property of the firm will be applied for the first in the payment of the debts of the firm, and if there is any surplus, will be distributed by the partners. Property of any partner shall be applied first in the payment of his separate debts and then only in the payment of the debts of the firm. Correct? Okay, moving on to the next question. Oh, okay, this question was there in the Jan paper, and I'm going to read the question. I'm expecting you to give me the answer. Okay? I'm expecting you to give me the answer, and only then we will discuss the answer. The Institute of Science and Technology, Dehradun, who is the buyer, placed an order for various chemicals worth 1,50,000 from a supplier in Delhi, the seller. The buyer made full advance payment and the seller dispatched the goods via courier of his own choice without reserving any rights of disposal over the goods. Okay, I will not give you the answer. The consignment was lost in transit and the buyer seeks a refund of the purchase price. Assess the validity of the buyer's claim for a refund. What do you think? Can the buyer claim for the refund or not? Tell me. Do you think the buyer can claim for the refund or not? Tell me. I'll not give the answer unless you tell me this one. You have to tell me the answer to this one before I give you the answer. Okay. Okay, Viksha. What about the others? What do you say? Buyer cannot claim, the buyer will bear the loss. Okay. So basically, you know what? This kind of answers the question here. So here, what you will write is when the goods are sent to the carrier, right? And the seller has not reserved the rights of disposal. You have not reserved the rights of disposal. So the moment you send the goods to the carrier, ownership is transferred to the buyer. Correct? The ownership is transferred to the buyer. So in case the goods are sent to the carrier, so this is where what you have to actually write here. When the seller delivers the goods to the buyer or to a carrier for the purpose of transmission to the buyer and does not reserve the rights of disposal, he has unconditionally appropriated the goods. See here, the goods were various chemicals, only a description is given. In case of this, the ownership is transferred when the goods are ascertained and appropriated. Here, the goods have already been dispatched to the carrier without reserving the rights. It's an unconditional appropriation. So, whenever the goods are given to the carrier without reserving the rights, ownership is transferred to the buyer as soon as the goods are sent to the carrier. Because here rights were not reserved, the ownership lies with the buyer. Now, if the goods are lost, who will bear the loss? Buyer. Can the buyer claim the refund for the money? Absolutely not. So many people attending the session, only 3 people answering. Not done. Everyone should be answering. Okay, I want you to answer this question, and this one I want you to tell me the provision, because I saw a few answers where the students have given the answer correct, but the provision was not the provision that we were looking for. So I want you to tell me the provision as well as the answer for this question. Okay? Siddharth visited an authorized car showroom and purchased the car of his choice without conducting a detailed inspection. After making the payment and taking delivery of the car, he discovered a defect in the engine that could not have been detected even with a reasonable inspection. He found a defect which could not have been what? Detected even with reasonable inspection. With reference to the provision, advise whether he can invoke the implied condition of merchantability and repudiate the contract due to the defect of the car. Okay, I want an answer from all of you. I'm not giving the answer to this. Okay, goods are bought by description. That will be your provision. That will be your provision. Okay. Okay. What about the others? What do you think should be the answer? Tell me, guys, what will be the answer? I'm waiting for your answer. Only one has answered. Okay. I saw a few answers where the students have written here caveat emptor. Please, guys, understand they have told you that advise whether he can invoke the implied condition of merchantability. They are telling you answer on the grounds of merchantability. So obviously this will not even come here. Correct or not? This will not come here. So what am I supposed to write here? It will be about merchantability. Condition as to merchantability. That is what you're supposed to write here. Not caveat emptor. Now see, if this line was not given, right? If this line was not given, let's take a question. If this line was not given, he did not even conduct a detailed inspection, cannot return the goods. But they have given, had he even conducted it, he couldn't have found it. That means what? It was a defect which could not be found on examination. ठीक है, हाँ, exactly guys, both of you correct. So it was a defect which could not be found even on examination. See, in exams, you have to identify, break the question, identify the keyword which is giving you the answer. You need to do that. So here, obviously, we are going to write about merchantability when the sale is made by description and the seller deals in those type of goods. It is implied that he will supply the goods which are in a merchantable state. If the goods are not in a merchantable state, the buyer can return the goods back. Since here they have said, had he not even if he would have checked it, he could not have detected the defect. There was a defect in the engine. And if there is a defect in the engine, it makes the goods unmerchantable. So, can he repudiate the contract? Yes, he can repudiate the contract on the grounds of condition as to merchantability. So, see, let's see what's given in the provision here. Where the goods are bought by description, who deals in goods of that description, there is an implied condition that the goods shall be of a merchantable quality. Right? This is not sale by description. This is merchantability ka point. And even in merchantability also they say when the goods are sold by description and the seller deals in those type of goods, then in that case the goods must be merchantable. But if the buyer has examined the goods, this condition will not apply. But when we talk about here, it is given that even if he would have examined, he couldn't have found it. So can he return the goods back? Yes, he can return the goods back. Is it clear to all of you? Yes. Explain the classification of capital under the company law. Now, see here, the question is classification of capital. Had they given classification of share capital, you would have written equity share, preference share. They are just talking about capital. So what will you write? Authorized capital, subscribed capital, issued capital, called up capital, paid up capital. That is what you're supposed to write here. Its definition. Explain the advantages of LLP form of business. How does its legal structure make it a flexible and preferable business model? Also discuss the legal capacities an LLP acquires on registration. So basically they are asking you two things here. First, advantages of LLP, and second, they are asking you effect of. Yes, exactly. You're supposed to write that, Jaya. And second, they are asking you the effect of registration of LLP. So let's talk about LLP ka advantages. It's flexible, right? It is less complex in nature. The capital structure is flexible. It's easy to dissolve. Then again, it is easy to form. It operates on the basis of an agreement and not as per law. The partners have limited liability. What happens? What are the advantages on registration? It becomes a legal person, has a separate legal entity. It can sue and be sued in its own name. It can acquire, hold, transfer, or dispose of any property, movable or immovable, tangible or intangible. It can have a common seal if it decides to have one, and it can do every act which every body corporate is lawfully allowed to do, right? Now, moving on to the next part of the question. This question is there even in our material. We have discussed also this question in the material. Jaya, you have time. It is hardly. We have a LLP ka revision video also. Even if you watch that 1 hour video, you literally cover up everything. 6 marks are there. It will come with other chapters which you have done. So yes, it is always preferable to go and do that chapter. So yes, I would suggest you to do that chapter. Okay. P, Q, and R are partners in a construction firm. PQR associates. P buys cement on behalf of the firm from D. The cement is used in the ordinary course of the firm's business. P uses the cement for his personal purposes. The supplier D, okay, the cement is used in the ordinary course of the business. P buys the cement on behalf of the firm. The cement is used in the ordinary course of the firm's business. P uses the cement for his personal purpose. The supplier D, who is unaware of the private use of cement by P, claims the price from the firm. The firm refuses to pay for the price on the ground that the cement was never received by it. Referring to the provisions of the, okay. So first of all, a partner is acting in the ordinary course of the business, right? Referring whether the the firm refuses to pay the price on the ground that the cement was never received by it. Okay. In this case, what am I supposed to write? Please remember, whenever the question is about liability to the third party for a partnership firm, please always remember, please start your answer with a partner is, for the purpose of the business of the firm, both the principal and the agent of all the other partners. Try to make sure that you write this sentence whenever we are talking about business, right? The next, for any act of the firm, the partners will, the whole firm is liable if, don't forget to write, the act is done in the ordinary course of the business, and second, the act is done in the name of the firm. If acting in the ordinary course of the business and in the name of the firm, the partner does any act, the whole firm is liable. Act of the firm means any act done by all the partners, any one or more of the partners, or the partners of the firm. वैसे ये implied authority में नहीं आता. This is contractual liability, but still. So basically, you are going to write here about implied authority. And the first, you are going to write about the fact that a partner is an agent as well as the principal. Second, what you will write is, yes, exactly, Jaya, absolutely correct. Second, what you will write here is that if the act is done about the implied authority of a partner. Third, you will write if the act is done in the ordinary course and then the name of the firm, the whole firm is liable. So all of this should be there in your answer. So let's see here. The given question is based, okay, sections, it's okay. If you can remember, well and good. If you cannot, please don't write wrong sections. Okay. A partner is, see, I told you, is the agent of the firm for the purpose of the business of the firm, right? He gets the character of both principal as well as agent, and he can act for himself and his own interest in the common concern of the partnership. And where he is acting on behalf of the firm, he makes the whole firm liable. The general rule is what? That the partner is the agent of the firm for the purpose of the business of the firm, right? And he makes the firm liable only when the act is done in the usual course of the business and in the name of the firm. If it is done in the ordinary course and with the authority of the partners, right? Act of the, this is basically, they are talking about this contractual liability and liability for tort, which actually does not even come here because this is implied authority. But these provisions have to be there. Till this point, it has to be there in your answer, right? So on this basis, can we say that firm's contention is tenable? No. Because the act was done in the ordinary course, the firm is liable. What would be your answer if a part of the cement, so purchased by P was delivered to the firm by him and the rest of the cement was used by him for his private use? Doesn't matter, the answer still remains the same. He is, but can I here, writing answer still remains the same because the act was done in the ordinary course of the business, the firm is liable. This is my answer. But in the end, after both answers are written, can I still add? However, the other partners can recover from P the amount of the cement that they had to pay, that the firm had to pay. Yes, you can add this, and it's absolutely correct. Okay, and I'm going to, this answer you will be giving me. I'll read out the question. I want all of you to give me the answer to this. Okay? Unity Foundation is a newly incorporated company focused on promoting education and healthcare services in rural areas. The company is registered as a Section 8 company with a clear plan to reinvest all profits into its activities, and a license has been accorded by the central government. For the financial year ending 31st March, the company earned a substantial profit and transferred some amount to Messrs. ABC Associates. Subsequently, on the complaint of one of the members, the central government, after giving an opportunity of being heard, directed the company to be wound up on the ground that a partnership firm cannot be a member of a Section 8 company and it cannot transfer any part of the profit to the firm. Explain in the light of the provisions of Companies Act whether the ground taken for winding up is sufficient. So here two things are happening. First question is about firm being a member of a Section 8 company. Correct? And the second question is coming that profit was given to the firm. Profit of the company was given to the firm. Well, if a company breaches, if a Section 8 company, first of all, what are the objects? Here, I'm going to write what are the objects of a Section 8 company: to promote sports, science, arts, religion, charity, commerce, technology, environment. They do not distribute the profits. They reinvest they do not distribute dividend. They reinvest the profits into the business to promote its objects. This is the object. Now, the next thing that we will write here is that in case when a company gets a license of a Section 8 company, in that case, even a partnership firm can become a member of such company. After that, after all these two, what we will write is if the company breaches its objects, or if the company breaches the conditions subject to which the license is issued, or if the company acts against public interest, this license can be revoked. And when this license is revoked, any one of the three can happen. First, convert into a private or a public company, amalgamate, or wound up. This grounds is not justified because a firm can be a member of a Section 8 company. But a Section 8 company can never declare dividend. So this grounds is absolutely justified for winding up. But before the company is wound up, the company must be given an opportunity of being heard, and winding up must be in the interest of the what? In the interest, in the public interest. Only then you can wind up. So see here what the answer says. Let's see. So Section 8 company, as I told you, you're supposed to write about the objects of Section 8 company. Then, okay, then about the revocation. I did not understand, Jaya. What is your question? No, no, the partnership firm. The money was given to the partnership firm who is one of the member of Unity Foundation. Right? And the second one is we will write about the revocation of license part. Here they have not written about this, what you say. They have not written about a partnership firm can be a member. We should add that also. Okay? So hence the ground taken up for this distribution of profit is correct. However, the grounds taken for a partnership firm being a member is not correct. No, no, no. It has transferred the amount to ABC Associates, which is a partnership firm and is a member of Unity Foundation, not to Section 8 company. See, what is it given? It is given that ABC is a member of this Section 8 company, which is Unity Foundation, and this is a partnership firm, and they gave profit to this member. And we cannot give to the member, no? Did you understand, Jaya? Did you understand now? Okay. Pacific directors. Okay, okay. Pacific Private Limited has 9 directors on its board of directors. The company's AOA currently states that the quorum for board meeting shall be 1/3 of the total strength or 2 directors, whichever is higher. The company now intends to amend this article to specify that the quorum for the board meeting shall be 1/3 of the total strength or 4, whichever is higher. Advise the company on the procedure for including this entrenchment provision in its articles. Okay, since they have told you entrenchment, obviously you have to write about section 5 entrenchment clause, correct or not? Entrenchment clause means providing grounds which is more strict than which is applicable in case of a normal amendment of special resolution, right? So if I am talking about private company, if it any company can put the entrenchment clause at the time of incorporation, or they can later include it, yeah, or they can amend the articles. Tell me, without looking into the answers, tell me for such amendment whose consent is needed. I want this from all of you. For such amendment whose consent is needed. Tell me guys, jaldi say. Whose consent is needed? Whose consent is needed? When I add it as an amendment, okay, yes. Only Jaya is answering, rest no one is answering. If I'm adding it as an amendment, no, we don't need the consent of registrar, etc. If I'm adding it as an amendment, if I am a private company, I need consent of all. But if I am a public company, I need the consent by special resolution, that is 75%. Here, if you see, the company is a private company. So to add this entrenchment clause, they need the consent of all. But if what would be your advice if it was a public company, then they need to pass a special resolution, right? So see here, entrenchment clause. You can add this entrenchment clause either at the time of incorporation of the company or as an amendment to the articles. When it is an amendment to the articles, it must be agreed by all the members in case of a private company and special resolution in case of a public company. Should I also give a notice of such amendment to the registrar? Yes, I have to give a notice of such amendment to the registrar. Okay, notice has to be given to the registrar. So in this case, they can you add this with the consent of all the members. It will differ if it is a public company, then special resolution. Clear all of you? Yes. The reason I'm marking the answer because I want you to understand what all points should be there in your answer. What is an anticipatory breach? Discuss the legal rights and options. When prior to the due date, one party comes to know the other will not perform, it's an anticipatory breach of contract. The aggrieved party has two options. He may either cancel the contract on that very date or he may wait till the due date. If he cancels the contract on that very date, he can claim the damages. If he waits till the due date, then on the due date, if the other party performs, he must accept it. If the other party does not perform, he can cancel. It's an actual breach of contract. He can cancel and claim the damages. So see, it's a breach which occurs before the time fixed for the performance has arrived. When the promiser refuses or shows his unwillingness to perform, it is called before the time of the contract. It is called anticipatory breach. Right? How will I know? It can be either he says by words or by his actions. Right? If you remember, the girl runs away. Right? So what is the effect of anticipatory breach? I can either treat the contract as cancelled and sue for damages, or I may wait till the due date. If I wait till the due date, right, then in that case, if the other party still performs, he has to accept it. And if the other party does not perform, it will be actual breach, will have the effect of discharging the contract, and I will have a right to claim the damages. Is it clear to everyone? Yes. If he decides to keep the contract open, and in that period of time, the contract is discharged due to supervening impossibility, then the parties will have no claim. We always practice writing indirect questions. We never write direct questions. Please, before the exam, go and write a few direct questions also. Okay. So moving on to the next one, examine the validity of the following agreements under the provisions of the Indian Contract Act 1872 and justify your answer. Mrs. Deepika pays a sum of 20,000 to a marriage bureau to provide it's just to provide information. This is not a contract for marriage brokerage. So this is absolutely valid. It is not marriage brokerage. I'm just asking you information. Bharat agrees with Rahul to sell his white horse. Unknown to both. Unknown, that means it's a mistake. To both means what? Bilateral mistake. Right? Unknown means what? Mistake. Unknown to both. Both means what? Bilateral, right? The horse was dead at the time of the agreement. What will happen? The contract is void ab initio. Ayush sells the goodwill of his shop to Omkar. Ayush sells the goodwill of his shop to Omkar for 5 lakh and promises not to carry on such similar business within the local limits so long as Omkar carries on like business. So, he sells his goodwill. When I sell my goodwill, can I stop the other person from doing the same business? Yes. Not within the local as Omkar. This is absolutely what? Valid. Why? Because it is justified. It is what? It is valid. So, see here, the first one says it is in exchange of a service, basically providing, is valid. Second is what? It is both the parties are mistaken. So it's a bilateral mistake of fact. So in that case, what will happen? The agreement is void. Correct? Third, it is agreement in restraint of trade. But if it is a locha, seller of the goodwill can agree not to carry the business, and if it is reasonable, it is absolutely valid. Fourth wala, a property worth 2 lakh was agreed to be sold for just 22 lakh 50, sorry. A property worth 20 lakh was agreed to be sold for just 2 lakh 50,000 by a person of an unsound mind. He is a person of an unsound mind. Unsound mind cannot make a contract. It's void. Contract by a person who is not of a sound mind is void. So this contract is void. Clear? Can we go forward? What is a negotiable instrument? Explain its meaning and its sense and characteristics. How does a classify instruments as payable to order or payable to bearer? Negotiable instrument means it's a bill of exchange, a check, or a promissory note payable to or to the order of or to the bearer of the instrument. Now they are saying, what is the meaning of payable to order, payable to bearer? When the instrument is payable to a specific person or as per the orders of a specific person, we call it as an order instrument. What is a bearer instrument? When the instrument is drawn as a bearer, or the last or only endorsement on the instrument was bearer, was a blank endorsement. It's a bearer instrument. So what is a negotiable instrument? We'll obviously write the definition of negotiable instrument, right? Then payable to order, payable to bearer, as I just gave you. What are the characteristics? All the characteristics. It must be in writing, it must be a promise to pay, it must be an unconditional promise, it must be transferable from one person to another infinite number of times. The holder's title is free from all defects. It must be signed by the maker. It must be, the parties must be certain. The money payable should be money only. The money payable should be a certain sum of money, and it should be completed by delivery. Correct? It should be completed by delivery. I hope it's clear to all of you. Okay, discuss the major functions and specialized divisions of RBI. Okay. I mean, this, there is nothing to explain in this. In my book also I have given it as points only. You please remember it as points only. So basically it is a regulatory body. It is under the ownership of Ministry of Finance. Main function is control, issue and maintaining supply of Indian rupee. It also maintains the company's payment system. And what are the divisions? Bharatiya Reserve Bank Note Mudra is a specialized division of RBI. That is what they have asked, the divisions also. It established the National Payment Corporation of India as its another specialized division to regulate the payment. And what are the functions what are the specialized, another specialized division is Deposit Insurance and Credit Guarantee Corporation. Direct, absolutely direct question. Another one is they are talking about explain the key responsibilities and organizational structures of MCA. Same what is given in the book. It's an Indian government ministry. It is primarily concerned with the administration of Companies Act 2013, 1956, Partnership Act, LLP Act, Insolvency and Bankruptcy Code. It is responsible for the regulation of Indian enterprises in the industrial and service sector. It's run by civil servants of ICLS cadre, and they are selected by the UPSC exams. And the highest post here is Director General of Corporate Affairs. The next question, PQR. Okay, this is an interesting question. I want all of you to answer this question. Okay? PQR Limited, a supplier of electronic. I want you, chalo, you only go through this question answer and then we will discuss this. I want you only to go through this answer and then we will discuss. You go through this question, you tell me the answer and then we will discuss it. I'm waiting for the answers from all of you. Okay, but there are two situations here, no guys? There are two situations here. It's not one situation, no, there are two situations here. So give me the answer to both the situations. PQR Limited, a supplier of electronic components, entered into a contract on 1st August with PQR Enterprises for the sale of 1,000 units of microchips. The contract specifically identified the microchips. That means they are what? Specific goods, right? By serial number and confirmed that they were in a deliverable. So specific goods in a deliverable state. Okay. Stored in PQR Limited's warehouse. The contract stipulated that the goods will be delivered on September 1. If the goods are specific goods in a deliverable state, the ownership is transferred when? Immediately. On August 10, a flood occurred, damaged the warehouse, and destroyed the entire stock of microchips, including the 1,000 units intended. Who shall suffer the loss? Obviously, buyer, because buyer is the owner, right? What will be your answer if the microchips are not specifically identified? If they are not specifically identified, then in that case, the goods are unascertained goods. So you basically have to write two things here. If the specific goods are in a deliverable state, who shall bear the loss? And second, I mean, when does the ownership transfer and who shall bear the loss? And in case of unascertained goods. So let's see here what's given. Let's see what's given here. So first see, in case of unascertained goods, the property passes to the buyer only when the goods are ascertained. Right? Only when the goods are ascertained. In case of specific goods in a deliverable state, the property passes to the buyer when the contract is made and it is immaterial whether the time of payment or time of delivery has passed or not. Right? So in this first case, who will suffer the loss? PQR will suffer the loss. However, if the chips are not, see, they have asked you two questions, but 1 and 2 is not given. So you cannot write 1 and 2. And you cannot write the both the situations in the first case only, because in the first case you will write the basic case. So here, how will you write the second situation? Therefore, PQR will bear the loss. Then go to the next line. In case the goods are not identified, the microchips are not identified, they become unascertain, right? Properly like that. So in that case, PQR Limited will suffer the loss as PQR Enterprises has not got the ownership. So in the first case, when the goods are identified, PQR Enterprises will what? Suffer the loss. But in the second case, when the goods are not identified, PQR Limited will bear the loss. Is it clear to everyone? Can I go forward? Yes. A purchases a motorcycle from B and uses it for some time. It turns out that the motorcycle sold by B to A was stolen and had to be returned to the rightful owner. Stolen. Whenever it's stolen, what? Condition as to title. Correct or not? Right? Condition as to title. A brings action against B for the return of the price. A brings an action against B for the return of the price. Will he succeed? Will he succeed? Yes, because condition as to title. When the seller sells the goods to the buyer which belongs to someone else, in that case he is liable to give the what? If the buyer is deprived of the goods by the true owner, the buyer can claim the price from the seller. So here what will you write? You will write about condition as to title. Clear? What is a partnership deed? Explain its significance and list the key contents typical. So you'll just explain its a partnership when they agree. So okay, it is basically no one can transfer a better title than they themselves have. Okay, and implied condition as to right to sell the goods means he should be the real owner. This is seller's title turns out. This is condition as to title. Okay, this is condition as to title. In the instant case, A will not succeed in his action against, sorry. A will succeed. I'm so sorry. But anyway, we have done. I am going to the next one. A partnership deed is what? It is an agreement. There is no particular formalities. It can be in writing or verbal also. The document, if it is converted into writing, we call it as a partnership deed, and it has to be stamped as per the Stamp Act, and it has to be registered as per the Registration Act. What all should be there in the partnership deed? The name of the partners, the name of the firm, the nature and date of the nature and place of business, the day the partnership started, the day the partners have joined, how long the partnership will continue, profit sharing ratio, capital contribution. These are all the key contents of rates of interest on capital, drawings, advance, admission and retirement of a partner, how they will settle the accounts in case of dissolution, salaries, commissions that will be payable, the right to expel the partner. These are the provisions that will be there in case of a partnership deed. Why is it advisable to have the deed in writing even though it is not mandatory? Even though it is not mandatory, if it is in writing, at least we have a proof that this is, I mean, if there is any dispute, the deed can actually help us to settle our disputes. The duties and obligations of an agent towards the principal. So this is basically a question on what is the duty of the agent. So first, he must follow the instructions or customs. That means while doing the business, if the principal's firm follows any custom, the agent must follow that custom. Second, he must take reasonable care and skill. That means when he is doing the business, he should use his diligence, his care to do the business. And in fact, if he is not able to figure out what he should do, he should communicate with the principal. Then duty to render proper accounts, he must maintain proper accounts, and whenever needed, he must give a record of the accounts to the principal. He must communicate, as I already told you, that if he is not able to figure out what to do, he should communicate it with the principal. Can he make secret profits from the firm? Not to deal in his own account. He should not deal in his own name. And if he does, the principal can cancel the contract. And if he has made any profits, principal can recover that profits from him. He must not make any secret profits. Secret profits means anything over and above his salary. And if he does, the principal can claim that profit. He should not delegate. That means he should not appoint a sub-agent. If he has received any money on behalf of the principal, he must pay that money back to the principal, and he must not leak any confidential information of the principal. Moving on to the next one, Kanika purchased various cosmetic products worth 15,000. Worth 15,000 during the last week from Karthik, a shopkeeper, on credit of 1 month. After a fortnight, she makes out a blank promissory note signed blank. So that means this is what? Inchoate instrument. One thing, please remember, guys. One thing, to the holder in due course also, the person who is drawing is only liable up to the amount he has given authority. Okay? So here the authority was given for 15,000. Then Manish so you have to write about inchoate instrument here. Manish, who is the holder in due course, filled the amount of 17,000 from Karthik and on maturity presented it to Kanika. So here they are very specifically given that, even if you are a holder in due course, you can only recover up to 15,000. Actually, earlier we had seen that he can recover full extent of amount, but here it is specifically given he can only recover up to 15,000. So the answer should be he can recover only up to 15,000. Okay? She's only liable for 15,000. Going on to the next question. So you'll actually write about inchoate instrument. Don't forget to write what is inchoate instrument. If a person signs and delivers to another a paper stamped in accordance with the law then in force in India, and either wholly blank or having written an incomplete negotiable instrument, he gives a prima facie authority to the holder to make or complete the negotiable instrument by the amount covered by the stamp. Okay? So you have to write about inchoate instrument. Nisha, a small business owner, receives a bill of exchange from her customer Neeraj. I want you to answer this question. This is the last practical question here. Answer it and then only we'll discuss. Okay? Neeraj, which is due for payment on October 15th. On October 12th, Nisha presents the bill of exchange for payment at Neeraj's office during the regular business hour. But Neeraj is not present. Nisha leaves the bill with Neeraj's assistant, requesting to be presented to Neeraj for payment when he returns. However, Neeraj's assistant forgot to give the bill and Neeraj does not make the payment on the due date and the bill is dishonored. Based on the above, examine whether Nisha's presentation of the bill of exchange to Neeraj's assistant is valid. Tell me, what do you guys think? I am waiting for I want you guys to answer before I discuss this answer. Okay? This is a last practical question in this paper, so I want you to discuss. When we talk about presentment, it should be the presentment must be done. Um, the presentment must be done during the business hours and at the business place for payment. Presentment for payment must be done during the business hours and at the business place. Now, when we talk about presentment, if the instrument is not properly presented, the drawer is not liable to make payment on it. The instrument must be presented to the drawer himself or to his authorized representative. Here, she left it with Neeraj's assistant. Is he the authorized representative? No. So, because he was not the authorized representative, it's not a valid presentment. So, when she left it at the office, it's not a valid presentment. And if the instrument is not presented properly, the drawer is not liable to pay. So, examine whether Nisha's presentment, based on it, examine whether it is a valid presentment. So, presentment of is not valid under the law. Why? Because it should be given to the authorized representative. Here, it's nowhere given that the assistant is Neeraj's authorized representative. So, it's not a valid presentment. What are the circumstances where the contract of bailment may be terminated? Parties are dead, purpose is over, time is over, by notice of revocation, the subject matter for which the bailment contract is made is over. Then the bailee makes an inconsistent use of the goods, and if it is a gratuitous bailment, it can be terminated at any given point of time. Explain the concept of right to resell under the Sale of Goods Act. Under what circumstances can an unpaid seller exercise this rights? Okay, when an unpaid seller, after having exercised his rights of lien or rights of lien or having exercised his rights of stoppage in transit, if he still the buyer doesn't pay, then the seller can resell the goods. Before he because the owner is the buyer, he's selling it on his behalf, so he must give a notice to the buyer that he is going to sell the goods on his behalf. And the purpose of giving the notice is that he will wait for a reasonable period. If during this period the buyer pays the price, then he can take the goods, otherwise the seller may resell. Now what happens is, if within this time period the buyer doesn't pay, the seller will resell. If it's perishable goods, obviously I'll not give notice, because if I give notice only, by then the goods will only be gone. If I give a notice and resell and there's a loss, I can recover it from the buyer. But if there is a profit, I'll keep it. The seller will keep it. On the other hand, if notice is not given, here it's the seller's fault. In that case, if the notice is not given, then if anything happens, if there is a loss on resale, it will be borne by the seller, but the profit shall be given to the buyer. In case of perishable goods, it's deemed that notice has been given. So with this, we are done with mock test 2. Please do let me know if it was helpful. Then in that case, we'll also arrange a session for mock test 1 discussion. I hope you are studying. Whatever are the conditions, understanding everything, and with the inter test being postponed, now we are like, should I study or not? Please keep studying. Don't stop studying. Keep writing your answers, keep practicing, keep revising, and we are always there to help you. I'll see you again in the next video live session. Till then, thank you, happy learning, and stay motivated. Thank you so much, guys.